Hi, everybody. Thanks and welcome back to Conversations with the Care Navigator, also known as Mondays with Maureen. I'm Stephanie Wilson. I work at the Four Seasons Foundation. Our guest today is Koral Alman. You may recognize her from being a guest on several previous episodes. And we are covering for Maureen for a couple of weeks, and we're discussing various topics related to estate planning. Today, we're going to talk about advanced directives. And I'm going to let Koral introduce herself and talk a little bit about what that phrase advanced directives means. Before we dive in, though, I really want to give a huge thank you to the Winkle Law Firm. They are the title sponsor for Conversations with the Care Navigator, and they make these episodes possible. So, Koral, welcome back.
Thank you.
A little bit of background.
Yeah. My name's Koral Alman. I'm a partner at the Winkle Law Firm. I do exclusively estate planning and then estate and trust administration. So helping families on the front end. And then after they've lost someone. I am not your attorney by virtue of this recording. This is not covered by attorney-client privilege. You need to consult with your own attorney. I'm just here to provide general guidance and knowledge about this subject. So to answer your first question, Stephanie, which is sort of what is this topic? What are advanced directives? So there's lots of components to estate planning, but one thing that people often overlook, they worry about what's going to happen to my stuff when I die. I need a will. I need to make sure that this goes here, this goes there. And they forget to worry about, well, what if something happens to me while I'm still alive? And that is a very frequent topic of conversation I have during my client meetings is, okay, that's all great, but you're here. Let's talk about what happens to you while you're still here on Earth. And those are documents that we prepare that allow people to help you during your life manage your own affairs, whether it be healthcare, financial, or otherwise. It allows people to step in for you when you are unable for one reason or another to do that. So healthcare power of attorney, advanced directive or living will, general durable power of attorney. And then we also always do a HIPAA authorization. Some states combine those with other documents. We do that as a standalone. So that's sort of the broad overarching category that we're talking about today.
Can you go into what each of those documents defines?
Yeah. So I always do this with Maureen. These are like my during life documents, and this is my after you die document. So there are 4 that we at least prepare to help take care of folks while they're alive. The first is a living will or advanced directive. That is dealing with end of life decision making. It presumes that you do not want to be kept alive artificially, and it gives legal authorization and guidance to your healthcare agent under the healthcare power of attorney about how and when they should take you off of those life prolonging measures. It is not a DNR, a do not resuscitate, nor is it a MOST form. That's a medical order for scope of treatment, MOST. Those are both medical orders that have to be entered by an actual doctor. I always joke, I'm not a real doctor, I'm just a juris doctor. I cannot do a DNR or a MOST form. The second document is a healthcare power of attorney. Some states call it something different. I'm also licensed in Florida. That there it's a designation of a healthcare surrogate, same sort of concept. Who is going to make healthcare decisions for you when you are unable to communicate those decisions for yourself? Whether because you are incapacitated, you're in a coma, you are non-responsive in some way, or you don't understand, you have advanced dementia or some sort of cognitive loss, and you can no longer appreciate the options presented to you by your medical team, and you need someone to make those choices for you. The third is a HIPAA authorization. So like I said, some states combine the HIPAA, which is your protected health information. Doctors and physicians and offices are not allowed to share your protected health information with other people without you consenting to that sharing. And to do so without that consent is a HIPAA violation. So we prepare a HIPAA authorization, which allows your doctors, nurses, care team to communicate your health history, health needs, and care plan to the people you've appointed in fiduciary roles so that they can have educated and make educated decisions about your care. The fourth document is a durable general power of attorney, and that is dealing with financial decision making. But when we say financial, we're not talking like just writing checks or paying bills. I sort of think of it more as all of your non-health care decisions that need to be made. So requesting 1099s, filing taxes, moving money between accounts, paying bills, opening accounts, closing accounts, selling real property, mortgaging or buying real property, all of assigning contracts. So when clients are checking their aging parents into a care facility, they might be making a healthcare decision under one document, but someone needs to sign that agreement with the assisted living facility or whomever, and they may be doing so under a durable power of attorney. So those two roles, I'm skipping ahead a little bit, but your healthcare power of attorney and your durable general or financial power of attorney do not have to be the same person. They often are, but some families, I mean, the common one I have is, oh, well, Julie's a doctor. She's definitely going to do the medical stuff, but she's terrible with money. And so her brother's going to do the financial, or she's going to do the financial because she's really detail oriented, but she's like a little too emotional to deal with the end of life stuff. So her other sister is going to do whatever. But finding people you trust for those various roles is really important so that you have a support team to take care of you in the event of your own incapacity.
Wonderful. Wonderful. I imagine that this is just like we discussed when we had a segment on the importance of having a will.
Yeah.
Doing this is a huge gift to your family. Can you talk a little bit about that and the difference of when somebody doesn't have what can disrupt or cause issues?
So there are two big pressure points, I think, when these documents come into play. One is in the event of some sort of accident, event, something, and someone needs to jump in pretty quickly and take care of someone's medical and financial needs. That can happen to anyone at any time. Once you are 18, your parents can no longer just do those things. So the joke in our office is once everyone's kid turns 18, that's their birthday present. You're coming in and signing powers of attorney. Because you need to have the opportunity. So if there's a catastrophic event of some sort, you need to make sure someone can step in. The other pinch point is my much older clients. So my clients that are 99, 100, 105. There are lots of clients, particularly in our community, that are much older. And frankly, some of them are just tired of paying their bills. I have been doing that. I've been writing checks for 80 years. I'm going to let my son, who's 70 years old, start doing that, right? They're over it. And they would like someone else to just help stay on top of it. Or because of technology, they don't feel as adept at banking as they once were. Mm-hmm. If you do not have those documents and you can no longer execute them because you either are incapacitated, you have dementia or Alzheimer's or something, or you're in a coma or have a traumatic brain injury or something, the only option for people to help take care of you is to pursue a guardianship. It's sometimes called a conservatorship in some jurisdictions. In North Carolina, it's a guardianship. Mm-hmm. There are two components to a guardianship, or there can be. There's the guardian of the person, which is sort of the healthcare power of attorney piece. What is happening to their physical body? What doctors are they going to? Where are they living? That sort of stuff. And then there's the guardian of the estate, which is more financial. Who's paying the bills? And there are, one, it's a very time-consuming public process to get someone determined to be incompetent sufficient that a guardian needs to be appointed. We would like to avoid the time, trouble, and expense of that sort of procedure of a guardianship proceeding if we can avoid it. If you could appoint the people you want to do it, then we don't have to have three other people fighting over who should, right? You've already made that choice for yourself. The other piece of this is that it involves, at least to some degree, the stripping of rights and liberties, right? Mm-hmm. And we want to avoid that for clients at all costs when possible. Sometimes it is not possible to avoid it, but when it is, we want to avoid it. And then there are restrictions on what those people can do in their guardianship roles, which is, of course, designed to protect the ward, the person over whom a guardianship has been awarded. But it can make things really difficult because they can only spend income earned on the assets without court approval. Any use of principal requires some sort of court approval. That's a pain in the rear end. And we don't want to have that if we can avoid it. So you may have noticed that I said we try to avoid that, not always avoid that. And that is because the appointment of agents under a power of attorney, healthcare or financial or both, is only effective to the extent that you are a compliant patient. Okay. So, this doesn't happen often, but it does happen sometimes, not totally infrequently, where someone will appoint their child, their cousin, their whoever, who they do trust, who is a good person, who's not, scamming them, stealing their money, etc. But the way that their dementia manifests or whatever, they maybe have paranoia, they maybe have confusion about who someone is. And so daughter is going to the bank and trying to do their best to pay your bills. And every time they go to the bank, you're yelling, I don't know who this is. She's trying to take my money. The bank is not going to participate in that because they don't want to get sued. Or you're going to the doctor and she's screaming that I don't know who this person is and she's trying to whatever. The hospital, the doctor's office, they don't want to get in the middle of that either. And that's a really tricky spot because you have named who you want, but you are no longer, compliant in the plan. Again, that doesn't happen all the time, but I like to kind of flag that because people usually the kids will come back and they'll say, well, then why did she give you all this money back and, whatever, if I can't even use this power of attorney? One, I'm not really even allowed to talk to them. I got to tell them, you got to get your own attorney because my client is your mom, not you. But two, I try to preface the process with this of like, these only work to the extent that you participate in your own care helpfully, right? If you're resistant, then sometimes we have to get a guardianship. Again, that is not the typical outcome, but it can be. And I think it always highlights why you should really be appointing people you really, really trust in those roles. With the hope that whatever nugget is in the back of your brain will at least remember, well, she's not, that's my baby. She's not taking my money or something. But we can't always predict how things will work out, and we adjust as we need to.
So that brings up perfect segue to another question that's on my mind is adjusting. And sometimes things don't work out or your situations may change or your family situations may change. These are not locked in stone documents and they can be updated as often as need to be. Can you talk about some of the things that should trigger somebody reviewing these documents?
Yeah. So similar to really all estate planning documents, I always recommend clients look at these every 3 to 5 years and just eyeball them. Either walk it through with your attorney. I regularly have clients that call and we do a 30-minute sit down or phone call and I explain, okay, you've appointed your son and then your daughter or whoever in these roles. But if someone dies, someone gets sick, you've appointed your son-in-law and now they're divorced or something like that, we want to have a conversation about it. And do you still want your son's ex-girlfriend to serve in this role? Sometimes people do. Yeah, I love her. They just didn't work out, but I still want her to manage my finances. Great. But if something has changed dramatically, that's another reason. So we're looking at a regular interval of reviewing them every 3 to 5 years, but also in the event of a major change. Someone now has a significant adverse medical diagnosis, right? They have ALS or Parkinson's, and they're not going to be able to take on your financial care as well as their own life circumstances. We need to pivot at those times. The other kind of sticking point are for folks who don't have children. That is often sometimes a very difficult, who do I appoint in this role? Me and my husband, me and my wife, whatever, are 88. We don't have any kids. I don't want to put this on my niece who lives in Tennessee or something. There are options at least in our local community of folks who do that as a paid role, many of whom are very good. So there are options out there. It's not a reason to ignore the problem. It's frankly a reason to be really proactive. So.
You need to pause. I had a question that came up. Oh, sorry, Ivy. Are there times? Stop. I don't know how to.
We are not live. It is totally cool.
Would you say, and I don't know, Koral, if you're allowed to answer this or not, if it's an advice type question, is it beneficial to let somebody know that you have named them as a specific role in any of these documents?
So there are kind of different schools of thought. I think in power of attorney documents, I'm more of an advocate for sharing that information for a couple of reasons. One, you want to know now if that person's not going to do it, because then we can go ahead and name someone else. But two, those people you're appointing are often in a role that they're going to be the ones who identify your incapacity in some way or another. You know, so and so is writing checks to some scammer and getting gift cards every day from CVS. Like I think I'm the power of attorney. That's the phone call I get. I think I'm the power of attorney. I don't really know. They need to know how to get a hold of me and get a hold of or whoever your attorney is, get a hold of the right person to get copies of the documents and make sure they understand their role and all of those things. They need to know that they have that duty. I feel a little differently sometimes about the terms of your will, because people often change their mind. You know, we've had a rocky relationship, but you know, I'm close to my son now, so I think I'm going to add him back in. I'm not always as inclined to be like, oh yeah, show him that document, because I don't want to create an expectation of receiving something at their death, which we may change. You know, that's a living document too. We can change that.
Mm-hmm.
But at least with respect to appointments under powers of attorney, even if you don't give them copies of the document, I at least want them to know that you are named in this document and to whom they should contact, you know, reach out if something happens to me. As part of our practice, we also give out wallet cards that folks can put in their wallet that says, my healthcare documents are on file with Koral Alman at the Winkle Law Firm, and it's my contact information. And I tell them, one in your wallet, one in your glove box. And that way, if you get into an accident or something happens, you know, your named appointee may not be in the car with you. We hope they're not, frankly, because we need them to step in. But the EMTs know how to get a hold of someone. The hospital can help get a hold of someone. We're trying to cover all of our bases as best as we can. And one thing I often suggest when it's my clients, particularly depending upon the age of your appointee, not everyone keeps business cards anymore. But if you forwarded my signature block from my email to your kid who's 28 and the subject line was just like mom's attorney or something, if something happens, he can search his email and find, oh, here's Koral's contact information. So that's often what I tell clients to do, is just forward my contact. Don't forward my attorney-client communications with you. That waives the privilege. Delete the conversation and just send my contact info or my link on my bio or something.
Well, that is very smart input. Thank you. For anybody who knows that they need to do this, but they haven't taken that step, or there's something that's still making them hesitant, what encouragement would you offer?
Oh, I mean, who doesn't want to have a say in their own affairs in some way or another? One thing that people often also think is that if I appoint this person as a power of attorney, I'm giving up control. They think of it as like my kids are taking my driver's license. We are not doing that. I won't go into my bucket analogy of coextensive powers that I sometimes do, but to the extent you can manage your affairs, you are still doing that. Even to the extent that you need help, but you can do some of those things, you can still do the things you can do and allow your agent to step in on the things that you can't do. And then similarly on the healthcare power of attorney, this is where Maureen and I's work often overlines. Although she cannot serve as a healthcare power of attorney, or none of, the Care Navigation team can't do that, they can also help facilitate, making sure you're understanding what your physician is explaining to you, or understanding your care options, or understanding, yes, you should stay here, or no, you're free to go to a different facility or something. There's a lot of support that you can have when you take affirmative action versus just letting the world come at you. And that's, head in the sand almost never works. So
Well done.
thank
Well,
you, Stephanie.
thank you very much. I hope that anybody who's listening today that has questions is feeling inspired. If you have questions for us at Four Seasons, you can definitely reach out to us. The foundation does have resources to help people think about what they need to think about, and we can offer recommendations for local attorneys as well. So thank you all so much for joining, and we'll talk to you next time.